Good evening, welcome to Policy Exchange. My name's Dean Godson. I have the pleasure of being your host tonight for the award of the Grotius Prize 2026. I don't think there's ever been a prize, the title of which attracted so much attention, indeed even criticism. The number of calls which I've had from proponents of, eminent proponents of educational reform saying, doesn't Policy Exchange know how to spell any longer, with the title Wither? And I have to say that indeed one former head of Ofsted called me, asking me whether Policy Exchange had now moved away from its support of the Gove reforms, and wasn't with this misspelling, wasn't this sign that the UK's PISA ratings were soon going to plummet dramatically. But as you all know, the title, the spelling is quite deliberate at this key inflection moment in international affairs and indeed in international law as a whole. Indeed, such an inflection moment that many of you will have spotted the Attorney General's own attempt to preempt this great award tonight with his remarks at the Harry Street Memorial Lecture at Manchester University, his alma mater. This must be the sole time during the course of his career where the Attorney General was ever in favour of preemption. But I'm glad to have that we have created the context for this. And the purpose, as you know, of all think tankery is to ensure that people sort of, as it were, stretch their minds, think out of the box, to move away from consensuses, to educate the public, and to increase the terms of debate. And this is particularly important in the area of public international law, and in particular the connection between national security policy and international law. And that's why we're delighted to move out of the box and have this multidisciplinary conversation between John Bew, previously Foreign Policy Advisor to 4 successive Prime Ministers, including the present one, across party divides, author of a distinguished volume amongst many others, Citizen Clem, winner of many literary awards, and that's why he's here tonight to talk with Lord Verdirame. Now, we've had many distinguished recipients of the Grotius Prize in years gone by. Scott Morrison, as Prime Minister of Australia, for his part in articulating the case for a free and open Indo-Pacific. Kaja Kallas, then Prime Minister of Estonia, for her part in keeping the flag flying with the assault on her country, and now, of course, as EU Foreign Affairs Commissioner. And then finally, several years ago, Giorgia Meloni as Prime Minister of Italy, for her part in breaking with some of the more discreditable traditions of the Italian right vis-à-vis Vladimir Putin. It's indeed interesting that Lord Verdirame is, I think, the only British Italian in Parliament now, that this should take place on the day after she lost the referendum on many of the subjects that have been under discussion in this country in recent years on judicial reform. I should also note, the ballot being secret, that Lord Verdirame's part of Italy, from whence he comes from originally, Reggio Calabria, was the only part of the Mezzogiorno to vote for the Meloni reforms. I make no further comment on that particular side of things, but the purpose of tonight is just as Policy Exchange's Judicial Power project, so brilliantly headed by Professor Richard Eakins, who's, I'm delighted to say, is also here tonight, is the purpose of this discussion is to open up discussion more widely on whether the balance indeed between international law and national security has been got exactly right under this government, but also under previous governments as well. And of course, Lord Verdirame may be the only one of our prize winners to have a complete and total command of Grotius's own writings. His career has one or two echoes. I think even his mother might blush at some of the measure of the comparison with Grotius. But like Hugo Grotius himself, the founding father of international law, of course, he has written books on international law. He's contributed to legislative debates as the preeminent practitioner of public international law, I think it's fair to say, in either House of Parliament. I think the only thing which he probably will not have in common with Hugo Grotius is that he will, I think a betting man would put money on the fact that he has never been a key player and never will be a key player in the Arminian Calvinist debates. But apart from that, his intellectual pedigree is so very well attested to. One of the aspects, I'm violating Donald Trump's one of his key nostra on how to negotiate the deal. And of course, he always says, never give something to somebody before they've given you something in return. So I'm violating his rules by giving him the Grotius Prize now. Grotius's most famous text on the law of war and peace. And it may yet be that Guillermo does a runner before all of this, but he's assured me not. So in violation of that, here, this wonderful volume. The smell is absolutely fantastic. I can assure you, like all near original editions. Just take a quick whiff of that. Smell if not the coffee, the Grotius. It's brilliant to have you here, brilliant to have John here. You will talk for half an hour. We'll then have a dialogue between you and John, and then throw it open for questions. John will reiterate this point later, but no question too outrageous. You just first have to state your name and organisation. So congratulations, Guillermo.
Thank you very much. Let me move the water away from Grotius. It is a great privilege to receive the Grotius Prize and this wonderful book, I think 1725 edition. And I would like to express my sincere gratitude to Policy Exchange and to you, Dean, for this recognition. I'm particularly delighted because for many years at Cambridge and then at King's College London, I taught a great books course for international lawyers. Grotius' Laws of War and Peace was, of course, one of the great books we covered. In the introduction to his greatest work, Grotius famously wrote that he wanted to identify a law of nations that would remain valid even if we assumed that God does not exist. In 1625, in a Europe divided by wars of religion, there was no prospect of agreeing on God. A law that applied to all nations could not be developed on the basis of shared religious belief. What Grotius proposed as the foundation for the law of nations was not a grand new theory, but a more modest idea, that rules could be distilled from consistent patterns in the settled practice of states. Because Grotius declined to ground international law in a universal moral theory, Immanuel Kant dismissed him as a miserable comforter, which is how Job in the Old Testament described friends whose advice only deepens one's misery. Grotius, however, did believe that moral values had to form part of the law of nations, but he thought that these values had to develop organically and incrementally, rather than be imposed by a particular political or moral ideology. The law of nations could only succeed if it charted a careful course between political reality and moral aspirations. Martin White, the great post-war international relations scholar of the so-called British School, suggested that there are three main sensibilities in international law. If you're apt to think of moral problems of international politics as simple, he wrote, you are a natural Kantian. If you think the moral problems are non-existent, bogus, or delusory, you're a natural Machiavellian. And if you're apt to think them infinitely complex, bewildering, and perplexing, you are probably a natural Grotian. It is perhaps a crude classification. In fairness to Kant, he did offer one of the most compelling critiques of the idea of world government, warning that it would lead to soulless despotism. But what White says about Grotius is quite right. One of my arguments is that there is too little Grotian sensibility in the way we discuss international law these days. The prevalent approach has become more dogmatic and ideological, and often unmoored from a true understanding of history. The confusion runs so deep that those who still approach international law in a Grotian way are today at risk of being associated with Carl Schmitt, the Nazi jurist. The Grotian sensibility, attentive to practice, skeptical of grand abstractions, and conscious of the tension between moral aspiration and political reality, provides a lens through which we can better understand the evolution of the international order and the crisis we face today. So I will start with the evolution of that order from 45 before turning to issues that are relevant to present debates. On a sort of literary festival version of the history of international law, it was in 1945 that a morally infused and idealistic rules-based order was born. It is that order which on that same account is now collapsing. Dr. Andrew Earhart in the Department of War Studies at King's College London, where John Bew and I teach, has written an excellent book on British strategy and the origins of the United Nations, which provides a more complex account, albeit perhaps no less uplifting for what it tells us about the combination of British internationalism and realpolitik. Rules were one of the main pillars, and are one of the main pillars of the United Nations Charter. In particular, principles like the prohibition on the use of force, the sovereign equality of states, and the peaceful settlement of disputes. But the other pillar, and probably the one on which British strategy was most closely focused, was the creation of a new concert of great powers. After San Francisco, Sir Charles Webster, one of the British diplomats most closely involved with the drafting of the Charter, wrote to Lord Halifax, "The heart of the organization is still that concert of great powers, inside an ordered system comprising states great and small." The idea was that the alliance between the United States, Britain, and the Soviet Union would continue after the war. At the US insistence, China was added to that trio, and so was France, not least because, with the brilliant coup de théâtre of the Franco-Soviet Treaty of Alliance in December 1944, de Gaulle made it clear to the Anglo-Americans that France was going to behave like a great power whether they liked it or not. The great powers would guarantee world security by addressing promptly and effectively not just aggression, but crucially threats to international peace and security, using the powers of enforcement under Chapter 7 of the United Nations, a charter over the exercise of which they each had a veto. They would use their own military power, but also draw on the forces that all UN members undertook to place at the disposal of the organization under Articles 43 to 45 of the Charter, while Article 47 established a military staff committee composed of the chiefs of staff of the 5 permanent members to provide strategic direction. Articles 53 and 108, seldom mentioned these days, preserve the possibility of unilateral enforcement against any state that had been an enemy state in the Second World War in the event of the renewal of aggressive policy by that state. These provisions may be dead letter now, but it is disingenuous to speak of the rules-based order of 1945 without taking them into account. They were central to the conception of that order. The Charter's formulation in Article 51 of the right of self-defense if an armed attack occurs appears on its face to exclude anticipatory action. Yet, unless this language is understood within the wider security provisions that I have briefly outlined, we are left with a completely ahistorical and distorted picture of the post-war order. No one in San Francisco imagined an international order that would legally oblige them to wait for a Fourth Reich to cross the Rhine before taking action. The idea of world order in 1945 thus diverges quite substantially from today's somewhat revisionist, starry-eyed accounts. It was a rules-based order alongside a power-based order. It was an order that reflected a far higher dose of realpolitik than the order of 1919, which had been shaped to a large extent by Wilsonian idealism. It is also important to recall that this order was conceived in a world where nuclear weapons did not yet exist. The UN Charter was signed 3 weeks before the Trinity test in New Mexico and several weeks before Hiroshima. The crisis of the 1945 order began at conception. Even the United States and Britain were divided by a fundamental difference, the future of the colonial empires. With the inception of the Cold War, it soon became clear that there was no concert of great powers capable of ensuring international peace and security. The UN exercised its collective security function in the Korean War, but that was just because the Soviet Union was empty chairing the Security Council. After the Cuban Missile Crisis, and to some extent prompted by that crisis, cooperation between the great powers slowly resumed, and in the 1960s and 1970s, a new architecture of collective security was put in place. Before looking at this architecture, I will just mention one interesting aspect of the Cuban Missile Crisis that is quite relevant to current debates. The legal advice received by the British government in October 1962 was that the American naval blockade of Cuba was illegal. The Labour Shadow Attorney General, Sir Frank Soskis QC, took a more hawkish view and disagreed with that assessment. But the senior lawyers in Harold Macmillan's government were unanimous. Even if Kennedy's blockade was a breach of the Charter, however, everyone was clear on one thing. It was in the British strategic interest that the US should prevail. Macmillan did not consider that what statesmanship required of him at that point was to broadcast the legal advice he had received to the nation and to the world. Instead, he gave unequivocal political support to Kennedy. When asked about legality in Parliament, Macmillan replied with evasive words, and incidentally, Chancellor Merz used similarly evasive language in the Oval Office a couple of weeks ago. Chancellor Merz said, "Now is not the time to lecture our partners and allies." 2 months after the Cuban Missile Crisis, in December 1962, Britain and the United States concluded the Nassau Accords, which gave Britain Polaris. It is difficult to imagine the United States sharing nuclear weapon technology with Britain if Macmillan had chosen instead to pick a very public fight with Kennedy about international law in the middle of the Cuban Missile Crisis. But let's go back to how international law changed in the 1960s and 1970s. The new security architecture was built in those decades through the reactivation of great power diplomacy and the development, through that diplomacy, of a new series of international agreements designed to lower the risk of conflict. The first one, a few months after the Cuban Missile Crisis, was the Hotline Agreement, to establish a direct and secure communications link between the White House and the Kremlin. Even this modest arrangement was initially controversial. In the 1964 election, the Republicans accused the administration of alienating allies by opening a hotline first with a sworn enemy rather than with a proven friend. But efforts to build this new security architecture continued and in fact gained momentum under the Nixon administration. The law of strategic arms control dates back to this period. The Soviets agreed to negotiate, not least because they feared American anti-ballistic missile technology would outstrip Soviet capabilities. After 3 years of negotiations in 1972, the Americans and the Russians concluded SALT I, the first strategic arms limitation talks, the main results of which were an interim agreement on offensive arms and the Anti-Ballistic Missile Treaty, the ABM Treaty. The multilateral legal regime on weapons of mass destruction was also developed in this period. The Nuclear Non-Proliferation Treaty, the NPT, in 1970, and the Biological Weapons Convention in 1972. The cooperation extended to attempts to regulate the future. For example, the Outer Space Treaty, which was concluded in 1967. And by the way, one of the problems we have today in international law is that the future has turned out to be very different from what was expected at a time during the Cold War, where, ironically, cooperation between the main powers made it possible to generate more international law to govern the future than it does now. We will probably have artificial general intelligence before a human makes it back to the moon. And yet we have some international law about space and celestial bodies, but none about artificial general intelligence. Before looking beyond the Cold War, let me pause here to see how this Cold War security architecture, which I've briefly outlined, has been unraveling. 3 dates capture this process. The first is October the 9th, 2006. That is the date when North Korea had its first nuclear test. The acquisition of nuclear weapons by India and Pakistan had been broadly anticipated, including by those states themselves. Neither had joined the NPT. But North Korea had. and its entry into the nuclear club was profoundly destabilizing. The second date is 27 February 2014. That is when Russia seized Crimea and began its attack on Ukraine. Ukraine, which had surrendered its nuclear arsenal in reliance on assurances from major powers, including Russia, was invaded by one of its guarantors. The third date is February the 5th, 2026. This is when the last nuclear pact between the United States and Russia, the New START Treaty, expired. For the first time in almost 55 years, there are no legally binding limits to the strategic arsenals of the United States and Russia. Again, this is not the unraveling of the 1945 international order. That order, as we've seen, bore little resemblance to the nostalgic version now invoked. The rules-based pillar remains in place, of course, but the collective security pillar gave way before it was ever put into effect. The international security arrangements that we inherited from the Cold War and were shaped by figures such as Henry Kissinger were not designed to be a complete substitute for the comprehensive system of collective security based on the concert of great powers that had been envisaged in 1945. But they were something, and insofar as they still in place, they are something that matters. It is a body of law that was conceived, developed, and overseen by policymakers assisted by foreign ministry and national security lawyers. It is also a body of law that can only ever last if it is underpinned by a balance of power. The distinction between right and might, which postulates a necessary inverse relationship between the two in international law, overlooks a central truth. In areas of international law that are most critical for our security, legal rights, even if embedded in treaties, remain largely aspirational unless they are underwritten by power. And if you give up might, you end up with less right. The expansion of international law after the Cold War is a well-known phenomenon. What is perhaps less well understood is the emergence during this period of a new conception of international law, one that now largely dominates, I would argue, public discussion about international law. This conception regards international law as the vehicle for a comprehensive moral and political project and views international institutions and international courts as its principal agents. The result is a far more ideological international law, one that is rhetorically confident but increasingly detached from statecraft and less capable of self-correction. This ideological turn in international law is accompanied by a radical, if simplistic, kind of Whig historicism, a conviction that the role of international law is to carry humanity along the right side of history. Once progress assumes a quasi-religious character, it generates a very different conception of the function and purpose of law in an international order. Law must be oriented towards the particular social and political values that are associated with that particular idea of progress. For this ideological conception of international law, states rather than the protagonists of the system, become obstacles on the path of progress. From the 1990s onwards, in much international law scholarship, terms like statist, state-centric, or national interest acquire a negative connotation. And if states are inherently suspect, NGOs are inherently good, not because of any democratic or popular legitimation, but because they are seen as agents of the right kind of progress. International law is thus recast as an instrument of declamation and denunciation, with NGOs or UN special rapporteurs as its high priesthood. The success of this ideology has meant that the grand theory that Grotius had considered so antithetical to the idea of a law of nations has found its way into international law, not via God, but by way of a secular substitute, whether human rights, which some indeed proclaim as a new religion, or an ideologized understanding of international law itself. How did this ideological turn come to impact the practice of international law? Its rise coincided with the post-Cold War expansion of international law. The multiplication of treaties, institutions, and adjudicatory bodies created an environment in which the ideological tendencies I've outlined were emboldened by the system's apparent success. A few wise voices warned that the expansion of international law required moderation. When international investment arbitration, now a major field of international legal practice, emerged in the early 1990s, the first academic article to be written on it concluded that this was a delicate mechanism. A single incident of an adventurous arbitrator going beyond the proper scope of his jurisdiction in a sensitive case may be sufficient to generate a backlash. The same warning could have been issued across every area of international law that expanded in that period: international human rights law, international trade law, the advisory jurisdiction of the International Court of Justice, or international criminal law. There are, however, important examples of rejection of adventurism, and it is useful to recall them before we look at what went wrong. When the International Court of Justice was asked in the mid-1990s to render an advisory opinion on the legality of nuclear weapons, some feared it might declare nuclear deterrence as such incompatible with the United Nations Charter, and thus drive a deep wedge between international law and the strategic doctrine which, for better or for worse, had been relied upon throughout the Cold War for the avoidance of conflict. Britain and the United States urged the court to decline to provide an advisory opinion, something it would have had good reason to do. The court did not, but its opinion was thoughtful. By the President's casting vote, the court opined that using nuclear weapons would generally be unlawful, but that legality could not be excluded in an extreme circumstance of self-defense. And, importantly, the court resisted the pressure and did not proclaim nuclear deterrence illegal. 20 years later, the Marshall Islands brought proceedings against all the nuclear-armed states for failing to negotiate disarmament. I represented the United Kingdom, led by Sir Daniel Bethlehem, who's somewhere in the room, but I can't see him. Oh, there he is. And the case was dismissed at the preliminary stage, again by the President's casting vote. And I think Daniel will forgive me if I recall that he faced considerable criticism on that occasion for spelling out in unvarnished terms the political implications of letting the case proceed to the merits. But that was an argument the court had to hear, and it had to hear it from the United Kingdom. The traditional British approach to international law has never been guided by illusion, but by clear judgment and, where necessary, robust engagement. Notwithstanding these examples, secured as we've seen by the narrowest of margins, the general trend has been one of almost unbridled expansionism. Nowhere is this more evident than in the field of international human rights law. This is an area that Policy Exchange has examined in depth over the years, beginning with its landmark work on human rights and war in 2013 and continuing with the Judicial Power Project. International criminal law is another area where, sadly, things have gone a bit wrong. For example, as Professor Eakins and I wrote last year, the statute of the International Criminal Court contains a provision, Article 98, which was inserted specifically to preserve the immunities of non-state parties. The ICC has simply ignored the clear language of its own statute and held that there is no bar to the arrest and prosecution of heads of state or heads of government of a non-state party. Unfortunately, such serious errors once made are difficult to correct. Once an international court or tribunal renders a judgment that crystallizes a bad interpretation of a certain rule, that interpretation becomes very difficult to unsettle or reverse. In principle, states can seek to amend the treaty, but in practice, when dealing with multilateral treaties, this is a complex process. In principle, courts could change course in a later case and take advantage of the fact that there is no doctrine of binding precedent in international law. But in practice, examples of such course correction in the international jurisprudence are quite rare. The fact is that once an expansive interpretation is adopted, it is rarely reversed. In domestic law, by contrast, we have many examples of Parliament intervening to legislate to change the law as settled by previous court decisions. We have several examples of this already in the current Parliament, but the point is perhaps best illustrated with a well-known historical example, the 1906 Trade Disputes Act, which changed the law after the House of Lords ruled that trade unions could be liable for damages caused by industrial action. If Parliament had not been able to change the law, British political and social history would have been different. Contrast this with the problem of immigration and the ECHR. There is now broad political consensus across Europe for tighter control on borders. Yet converting that consensus into legal change is proving remarkably difficult. This is not, unfortunately, a healthy dynamic for international law. Any legal regime that is incapable of course correction in response to social and political pressure exists on borrowed time. It is with this context in mind that I would now like to say a few words about our government's approach to international law. The Attorney General was right when he said at the RUSI annual lecture last year that we cannot abandon international law in favor of raw power. And he's also right about the many things that he said yesterday in Manchester. I haven't read the full speech yet, but there was a very good report by Joshua Rosenberg this morning. But what I still detect in the government's approach to international law is a certain ideological sensibility. This can be illustrated with the metaphor so often used to describe that approach. It is, the government says, the government's lodestar. A lodestar, which is fixed, constant, and beyond our reach, seems more appropriate to describe a set of immutable religious beliefs or an ideology rather than law. The liberal conception of law is that law is an ordering mechanism within which individuals or states, in the case of international law, can advance their interests and pursue their goals and aspiration. And not wishing to trade one German philosophical swipe with another, while not Schmittian, the idea of law is the guide to your destination in life as a rather Hegelian flavor. It is also at odds with the British tradition in international law. British law officers, while appropriately viewing international law as a constraint, also considered that it was something they had to shape in accordance with British values and British interests. Britain's campaign against the Atlantic slave trade in the 19th century is a textbook example of shaping international law to fit strategic and moral aims. With no peacetime right to stop or search foreign vessels, Britain had to develop legal foundations for its policy. It did so by often adopting interpretations that government lawyers these days would describe as very forward-leaning. A more recent example is the development of the customary rules on special mission immunity. For 2 decades, Foreign Office lawyers worked with counterparts abroad to consolidate the state practice supporting those rules. When the case came before our courts, I was lucky to be counsel for the SCO, we could show the existence of the customary rules by pointing to this practice that has been so meticulously gathered. Another example is Tony Blair's Chicago speech in 1999 at the beginning of the Kosovo War, where he set out the conditions under which Britain was prepared to use force on humanitarian grounds. The doctrine of humanitarian intervention was and remains very controversial in international law, but the then British government considered that such a doctrine was in the British national interest and made the case for it. Now, let me say something about the government's legal position on the Iraq war. And I should say I do have very serious reservations about the war, but I'm not persuaded that the government's published legal position is entirely sound, either legally or strategically. And I should also say, as a parliamentarian, that it's a bit of a pity that the position is published in documents that appear on website rather than by the Attorney General coming to Parliament to set it out. But I will make 3 points on that position. First, as with the Cuban Missile Crisis, this is not the first time. Is everything okay? No. This is not the first time that a British government has had to balance legal obligation with statecraft. Other Western leaders, including Prime Ministers Carney and Albanese and Chancellor Merz, have struck that balance. In the RUSI speech last year, the Attorney General said, and I quote, "Our international obligations are not onerous, but manifestly in this country's national interest." It is here again that I detect a degree of ideological inclination. No company would ever say that all its legal and contractual obligations are invariably in its interest. It depends. Sometimes they may not be. But starting from such a Panglossian premise risks overlooking the need for a careful and often difficult judgment. Second, having implied throughout that there was no case to be made about an imminent attack from Iran, the government statement on the 1st of March said that over the last year alone, Iran had been responsible for more than 20 potential lethal attacks on UK soil. If there have been 20 failed attacks in 1 year, does that not make the 21st one imminent? That statement also said that Iran's drone attack against the RAF Akrotiri base in Cyprus was launched prior to the announcement that Britain would join the operations in a limited role, which again implies that the previous day an attack was imminent. Third, and most importantly, I have reservations about how the government set out the position on targeting. The government says the legal basis for the British intervention is the collective self-defense of allies in the Gulf. And that means, according to the government, that we're only permitted to target missiles and drones launched by Iran and the missile facilities which the Americans are targeting using our bases. On March the 20th, the government extended the targeting to Iranian capabilities used to attack shipping in the Strait of Hormuz. Once an armed conflict has begun, however, the law of armed conflict allows the targeting of all military objectives, which includes at a minimum all military personnel and all weapons. The UAE alone has been attacked with hundreds of ballistic missiles and over 2,000 drones. 10 days ago, I asked in Parliament whether the government were really suggesting that a state that has come under such an attack can only target in response the specific weapons used against it, but that it cannot, for example, shoot down an Iranian fighter jet. The problem is that the government presented its decisions on targeting not just as policy, but as dictated by law. This was not a case of strategic self-restraint. The message was not, we could do more, but we're not yet. The message was, this is all international law allows us to do. The more recent statement, the one from the 20th of March, is more carefully phrased. But for the first 20 days of this conflict, we conveyed the impression to allies and adversaries that our legal approach to targeting in armed conflict has become far more benign than in the past, and in my view, than the law requires. And I suppose we may come to this in questions. I believe it also risks leaving us dangerously exposed to what comes next, and the more so if, as it seems right now, the Trump administration has miscalculated. Let me conclude by drawing some of these threads together. The post-Cold War expansion of international law multiplied treaties, institutions, and adjudication, but also produced overreach and rigidity where moderation would have been needed. As we indulge the illusion of a global order grounded entirely in rules and institutions, the already fragile architecture of collective security was weakening before our eyes. Strategic cooperation among the major powers will in time resume, and we should work towards that goal. But no credible and effective UN-based system of collective security is waiting in the wings. In this more dangerous and uncertain world, Britain will need both strength and dependable alliances. Our diplomatic tradition has long treated the rule of law as an instrument of order, but we cannot sustain that role if we lapse into passivity, approach international law ideologically, or treat it as something to admire from the sidelines. What is required is some degree of error correction in various international legal regimes and development and clarification in others. Britain should lead that effort, but if we remain wedded to an overly idealized view of the rules, others will step in to shape the field in our place. Thank you.
Excellent job. I hope everyone can hear me, ladies and gentlemen. Perfect. I love the idea, by the way, of government advisors as miserable comforters. It speaks very much to my own experience in that time. My job is to offer a brief response and a couple of questions, and I want to use as much time as possible to open it up to lots of distinguished members of the audience. We have an event in here, just to say, I think at 7:15 straight after, so I'll be brusque and quick. I warn you in advance in doing so. I want to start with a very brief comment, Guillermo, before going into a practical question. My comment, and you've already preempted this through your careful product placement of our colleague's book, is that you mentioned trading insults about Third Reich jurists, and you had your own response to that. I think it very, very important to say that the historical record speaks very much to this Grotian story. and this idea of an approach to statecraft which is deeply infused in British diplomacy in the 19th and the 20th century through thick and thin, in which the rule of law is absolutely a strategic goal of British policy, but it's an approach to international arbitration and order building that's based on an understanding of history, the balance of power, the power base in that as well. And there's examples of that being 1815 and the role of Lord Castlereagh and others. But the big example you talked about, 1945, much of that is about learning the lessons of a failed attempt to make a peace. You talked about Wilsonian idealism at the end of the First World War, and a sense in which the lessons of history, the importance of a base in which to build your legal superstructure, and connecting those two things was a vital approach to statecraft. It's interesting when the Foreign Office historians and advisors turned up at the Paris Peace Conference with memos about lessons from the 19th century. Woodrow Wilson famously wafted them away when he's presented one of these memos and said, "I don't want a whiff of Vienna about here." But those same historians and advisors reassembled in the context of the Second World War and began to take some of those lessons. So it's not a distinction between an idealistic tradition and a realpolitik tradition. The achievement of British statecraft is the marriage of the two, and I think that's a very, very important lesson. It's a noble tradition. Here is my product placement for the book you mentioned, our colleague Andrew Earhart's book. It strikes me that not enough is written about the hard yards of diplomacy leading to 1945, and plenty of preaching is done about what the world in which we're told was born in 1945. An important lesson. But let me get into sort of hard practicalities, sort of so what questions, as you and I from the academic world, but there are policymakers here who move pretty quickly to the so what question. So my so what question is, what does a Grotian sensibility, so a philosophical disposition, a way of approaching this, what does it mean in very hard practical terms in terms of UK foreign policy? How might you marry this idealist position on international law with some of those hard power realities you make? What steps would you take?
A number of steps. I suppose the first one is to realise that if the states that defend international law are weak, then international law is weak. And so we have to become stronger and spend more on defence. The second step is to accept that the collective security system has been faltering for a long time, and we are now at one of the weakest points in history in terms of collective security. And following on from that, I think we need to think of the strategies that we need in a world where there is very little collective security. And the role of lawyers is to help the strategists develop the rules, the statement, the state practice that can deliver those particular strategies. Remember, Grotius, his famous book on the law of the sea, was an argument for something that had not yet been accepted. The British position was that there was no freedom of the high seas. We thought, like the Portuguese, that you could annex the high seas. The Dutch had a different objective. They wanted freedom of the high seas. He made the case for it, intellectually but also legally, and that case ended up becoming law. We have to do that for things like, and I'm sure we'll discuss later, nuclear proliferation. Another thing that I've been saying for a while we should be doing is reviewing the impact of treaties on our current strategic position. Throughout the Cold War, we had quite a clear policy of avoiding treaties that affect the conduct of hostilities if the Russians and the Americans did not join. That changed after the Cold War because we simply did not think that we would ever be faced with an existential war in Europe. But what we haven't done is really go through the process of those decisions and think whether those obligations are still suitable to a situation where we might have to fight a war with Russia. And here, in fact, at Policy Exchange, we had a very interesting debate a while ago on cluster munitions and landmines, which are treaty obligations from which some of our allies in Eastern Europe have decided to move away. Another thing that I think we should do, as I mentioned, is lead in the process of treaty reform for treaties that do need change, the ECHR being the obvious one. And finally, the one way that I think we can try to steer the course of international law is if we intervene promptly whenever a development emerges that we consider does not suit our national interest. One example, the decision of the ECHR on climate change. There was an incredibly compelling dissenting opinion by the British judge, Judge Ike. That decision is something that any government in this country will find uncomfortable in terms of developing policy. Where is the state practice that sets out our distancing from that decision and tries to protect our future legal position? Or another example, on the ICC, we should also be setting out clearly what we think about those issues. So those are some things that set out how our approach to international law has to be far more proactive and try to change the course of international law in areas where it is not yet clearly defined in particular.
Okay, let me follow up with a question on Iran, and I want to do it in a way that reflects the changing circumstances versus what we had 2 weeks ago. So in practical terms, it is striking how much of the politics around the Iran debate, around UK foreign policy, has been framed around the initial legal advice. Because in substantive terms, of course, 2 weeks on, the US is using UK bases, and that was the initial debate as to whether or not this was a legal position. But you sort of tantalizingly began to look at further future scenarios. So let's consider that debate where it's at in the current moment in time, and then begin to consider the changing circumstances. And you again refer to some of the open-ended questions we may be left with in the context of what actually materially happens with Iran in the Gulf, and there's a lot of open questions. So in the last few days, you've had now, since the initial advice was given, the attacks on Akrotiri. You've had a missile fired in the direction of Diego Garcia. It's quite striking watching the position of the Gulf states, some of whom may be divided over the sagacity of the initial action, have growing concerns about what may be left vis-a-vis the Strait of Hormuz. So in a more difficult situation in which the Trump administration currently is a long way from achieving a lot of the goals it set itself, although those targets are missing. What did you mean about a sort of future legal framework for what comes next in an Iranian context?
I'll be careful about making predictions, but it seems to me that however this particular chapter in the war ends, Iran will have more enemies than it had before the war. Before the war began, there was one country that was absolutely determined to ensure that Iran would not develop nuclear weapons, and that was Israel. I suspect there are now more countries in the region that are at least as determined to make sure that a nuclear Iran does not happen. And so what that means, whatever happens in the next few weeks, is that the incentive to use force to prevent Iran from going nuclear has now become a much more deep-seated regional incentive. Now, international lawyers can turn around and say, you can't do it, because the test for imminence is very strict, and unless the nuclear attack from Iran is only hours or days away, you cannot use force. I've never found this particular kind of discussion particularly helpful, and for one very simple reason, one with which Grotius, Machiavelli, and Kant would have all agreed. You cannot legislate against self-preservation. And the legislator that thinks it can do that ends up only legislating for its own irrelevance. Those states will do whatever they think is necessary to prevent Iran from going nuclear. And that is a fact with which we have to deal. What I think we should be doing now is to try to articulate the conditions under which we consider Britain and other states and our allies in the region should be prepared to use force again against Iran if necessary to prevent it from acquiring nuclear weapons. I should say this is part of an old problem in international law. The Bush administration tried to solve it in a way that just didn't work with the famous preemptive doctrine in the national security strategy. That was too broad, it did not have the right qualifications, it scared everyone, it was never going to work as a legal doctrine. What began to happen afterwards was the attempt to articulate conditions that were legally and strategically more viable. And I think here I'll embarrass Daniel again, because he was part of some of those conversations in Parliament that sought to not have a general doctrine of preemption, but a legal doctrine of anticipatory self-defense against the risk of a catastrophic threat that was legally more viable. I think we need to go back to those discussions and not let this just be a discussion between academics, which is what has happened for the last 20 years. This is something that states have to shape through their own practice. But if our message at the end of this conflict is to Iran, you must not go nuclear, but we cannot stop you legally if you do, that message will not be a stabilizing message for the region. If our message is, you cannot go nuclear, you must not go nuclear, and these are the circumstances under which we may use force to stop you from going nuclear, that is actually a message that could deter Iran from pursuing a certain objective.
Okay, if I may, one more question, then we'll open up for the audience, and it's one on sort of lived experience. So we've had other issues vis-a-vis legitimacy of the use of force in different contexts. So over the time I was in government, for example, the UK engaged, and the current government did so also, in a series of strikes against the Houthis in a more forward-leaning position than a lot of European allies, so there are some exceptions to that in terms of involvement. If you take, I think, one of the untold stories or lesser spoken about stories is, alongside a story of fidelity to the rules-based international system, the UK, partly through the war on terror and close involvement with the United States, actually has quite a lot of flexibility when it comes to legal permissions to do some of the spikier things in national security without going into much of those sensitive areas. So given that sort of history of actually more flexibility than you might previously assumed, what do you respond to those who are concerned about the UK's future ability to prosecute war? Policy Exchange has published on the fog of law, lawfare, all these different challenges. I say, to a certain extent, my lived experience is there's more flexibility built into that system.
It is true that there is a degree of flexibility, but flexibility is something that doesn't just happen naturally. It's something that we have created patiently through our state practice. I'll give you a very important example, and I think very topical. When the last Labour government decided that the United Kingdom was going to become a party to the first additional protocol to the Geneva Conventions, it made a number of reservations that are extremely important to our strategic defence, particularly on the provisions in the additional protocol that deal with targeting. Those are key statements for British national security. If we want to retain the flexibility that we thought at that time was important, whenever we say something on targeting, whether it is about another conflict, Israel, America, etc., or our own involvement in a conflict, we have to keep those in mind. Because if we don't, we risk losing the flexibility that we had very patiently built over the years. Whatever we say can then be used against us, I'm afraid, in international law as in other areas. The other point that I will make is that I think during the war on terror, one of the big intellectual legal challenges was the relationship between human rights and the rule of armed conflict. And that's where a lot of tensions happened. The problems that we're going to face now are a bit different. They go back to those debates about preemption and nuclear proliferation, etc. And those are debates that were started, that were very unsatisfactory in terms of the state practice, such as it was at the time. But those are the debates that I think we have to go back to and try to develop in a way that is more sustainable for the challenges that we face.
Brilliant. I will open it up to questions. I have one observation brought to you from the youth of today, having taught a class earlier today at King's College London, when we went through the Chilcot checklist, which has sort of 10 things that occasionally appear on our desks in government in laminated form at times of difficult decision making. It's striking that in that checklist, number 5 is the legal implications of any action. How do we ensure action is lawful? Notice the action follows the legal response to that as well. And I wonder, as I open it up to you, well, the relative balance of lodestar versus crucial threshold in decision making. The other things in that are, why do we care? What is happening? What might happen next? What does success look like? All these other metrics for statecraft as well. So the legal ingredient is embedded. The question, I think, as I open it up from the audience, is whether it's a lodestar or a threshold or a fundamental basis in which parameters you operate. Lots of hands going up already. Let's take two together. The Pulse Exchange house rules that I will follow to the letter are no question too outrageous as long as you state your name and organisation. So let's take gentleman here, and then two gentlemen in the middle row. Yeah, and Mike is on his way to you.
Good evening, Tobias Elwood. Fascinating discussion, presentation. Thank you very much indeed. Hugo Grotius, how much can we contribute, his contributions to the Treaty of Westphalia, arguably the start of global order? And flipping from one end to the other, we now have Mark Carney writing off our current global order. You've got Donald Trump introducing a border of peace, an alternative vision as to how we solve conflict. And then China putting together the Shanghai Cooperation Organization, the One Belt, One Road, the BRICS and so forth, together, another construct. Three competing visions as to how our world should operate over the next decade.
Brilliant. And we'll take another question from the gentleman in the middle row. Name and organisation, please.
Yeah. Jonathan Turner, UK Lawyers for Israel. To what extent do the problems lie in the rules of international law, and to what extent in the factual assessments made by those applying them? Lord Verdirame, your comments on the UK government's position, legal position relating to the conflict, armed intervention in Iran, were essentially based on the factual assessments being made as to whether Iran, whether there was a threat of imminent attack on the UK. I could mention advisory opinions that are full of false factual assumptions, and the International Criminal Court's prosecutor's summary of the grounds of his application for arrest warrants, on which the court subsequently acted. Every phrase of every sentence was false on our analysis. And it does seem to me, at any rate, that this is a major problem for the rule-based system, that the way in which facts are assessed is defective.
You take this one.
So I think I can take those two questions together by going back to the Charter. And the key part of the Charter was Chapter 7. And the title of Chapter 7 is Action with respect to breaches of the peace, threats to international peace and security, and acts of aggression. Articles 39 to 50 deal with the promise of collective security that was being made to the world. Article 51 is on self-defense, and it says nothing in the present Charter shall impair the right of individual or collective self-defense. So in other words, those two elements were seen as both necessary to the maintenance of international peace and security. The element that has been malfunctioning is, as we know, Articles 39 to Article 50. And so what happens is that you have these alternative attempts to create order through various routes by other powers or regionally that Tobias Elwood mentioned. So you have that, and I don't think it's something that is going to disappear. We have to choose, as Britain, which kind of ordering mechanism, which kind of alliance we think is best suited to our interest and more principled. And then we have to develop the rules and the principles for that alliance to operate consistently with international law. I think facts are always quite hotly disputed, and one of the problems with the sort of focus on just the evidence of an imminent attack is that it leads to these debates about, where's the evidence, do you have the evidence, who has seen it, who hasn't seen it, why can't you publish it? And I think it is more constructive to start from an international peace and security perspective. It is unquestionably the case that a nuclear Iran would pose a significant threat to international peace and security. It's unquestionably the case because of the obligations under the NPT and because of the views of all those states in the region. So we need to do something before we get to the stage that Iran has a nuclear weapon, and to try to narrow the argument to is there an attack that might happen next week? Is it days? Is it weeks? Is it months? In some ways, I think misses the point and takes us down all of these various factual discussions and evidential discussions that are not ultimately what is going to deliver order and peace to the world. I think we need to look at it from another angle.
Brilliant. More questions? We'll take two in the front row, name and an organisation. We'll start with the lady there and then John Andre.
Thanks. Ruth Deach, House of Lords. I have read that in classical Islam, treaties were binding, full stop. But that in modern Islamic states, there is much more of a cavalier attitude, in that it seems to be their policy that if the treaty doesn't accord with Islamic beliefs and Islamic sovereignty, they can set it aside. If I'm right, how on earth can the rule of law apply in the way that we in the West see it, or in international law, if many countries are taking a completely different attitude towards it, and we might be tricked into thinking that a treaty is binding when the other side does not regard it as binding?
And then if you pass the microphone on.
Hi, I'm John Bew from Policy Exchange. And quite rightly, the lecture is obviously focused on foreign policy, but I wondered if you could quickly opine on the growth of international law and its impact on domestic policy in the UK and the daily lives of everyone here, and how you think that growth of international law is affecting people on a daily basis. Thank you.
Okay. On Baroness Deach's point, I think we've had that problem before, and most notably with the Soviet Union, and we knew that the Soviet Union did not take its treaty obligations as seriously as we did, and I'm sure that similar issues arise with different states. In some ways, we have to go back to the fact that some of these treaties must be underwritten by power, so we need to be powerful so as to ensure that our legal rights are defended. But in other ways, I think it is also the case that some of these agreements have quite sophisticated mechanisms of compliance and enforcement. And so even for a state that intends to avoid those obligations, we can make life very difficult for them. And that's where I think international law has become actually quite sophisticated. But there is no single answer as to the sort of mechanism of enforcement and compliance that works. Certain mechanisms work better for other mechanisms. And I think we have to be very streetwise when we enter into these obligations as to who we're entering them with and what those obligations require with that particular party. On the question of the impact of international law on domestic law, I think the main route has been under English law, the Human Rights Act, because of the relationship with the ECHR. That has imported, as we know, the obligations under the convention into domestic law. Our courts, for a long time now, have also taken the view that domestic statutes must be interpreted insofar as possible in a manner that would not put the United Kingdom in breach of international obligations. But that, if I may, is actually quite a light touch rule of interpretation, quite a sound one. It's one that we've had for a long time, and it is not really the main reason why international law shapes domestic life, social, political life more than it did. I think the main reason is probably the ECHR, and also the fact that there is more of it. We have chosen to enter into more treaties and derive a lot of benefits from some of these treaties, investment protection and trade, but as a result, our domestic policy development has to take those obligations into account.
Okay, brilliant. We have time for maybe 1-2 more questions. There's a gentleman here. Yeah, any other questions? It could be the last one. Oh yes, and gentleman here. Yes, and there's 2 rows. Thank you.
Dr. Mohammed Hasnathu from Bright Blue. What is interesting is that there still seems to be a lot of reference to international law, even amongst autocratic powers. So when Russia invades Ukraine, it still makes reference to international law. Even in the American regime, they still sort of reference international law. And I'm drawn to that analysis from Koskiniemi about legal imagining. And it does seem to me that the presumption is often made that international law is crumbling, whereas it's still in use a lot. And I wonder if actually that mythologizing force does actually reinforce its legitimacy in a way. So sort of that rooting it in history, and to some extent a false history, but it's always going to be narrativized in a way that reinforces its embeddedness. So I just wonder if actually are we jumping the gun with the extent to which international law is crumbling?
Okay, and then if you pass the microphone on to the gentleman at the end.
Thanks. I'm Jonathan Hall, Terrorism and State Threats Reviewer. Could you talk a bit about your intellectual opponents on the nuclear imminence point? Do they really believe that you should wait until days before Iran has got a nuclear weapon? I mean, presumably they've thought the consequence of that argument through, and they would try and rebut it in some way. I'd be interested to hear what you think they would say in response.
So starting from the first question, I think it's a very good point. And I wouldn't for a second suggest that international law is collapsing. There will always be some international law. The question is, what kind of international law do we have? And where are the crisis points within the system of international law? And as you very rightly pointed out, every member of the international community will seek to justify its conduct on the basis of international law. And that is not an irrelevant consideration. So it matters, and states want to be seen to act in accordance with it, and that itself is an important political fact. But it is also the case that there are certain areas of international law, collective security being the main one, where we do have a very serious crisis that is encouraging states to act outside what might be the rules in a world where collective security operated properly. I think on the question of who are the opponents in this argument, there is a vast academic debate on this question of imminence. I suspect, trying to be the advocate that makes the case against me, I suspect what they would say is that a doctrine of anticipatory self-defense is inherently destabilizing, because other states may be relying on that without evidence, and it would result in a world where there are more states that could find excuses for starting a war against another state. And it is, I think, true that at some level, if you are able to limit states to the point where the attack begins, there is some idea of rationality that tells you, well, in that case, there will be less war. What this idea of rationality does not take into account is the fact that a state that has that fear of national distraction is not going to think like that. And you simply can't tell them you have to wait until a few hours or a few days before the attack. They're going to act no matter what. And that's my point about self-preservation. It's a very powerful instinct, and you can't really legislate against it. And I think for states like Israel, but now also for other states in the region, a nuclear Iran is an existential threat, and they will not allow it to happen.
Brilliant. Okay. We probably have time for just one more question. Gentleman put his hand up there, and then we will wrap it up.
I think there are two dimensions of international law. The first dimension is rules that prevent ships crashing into each other, and rules for the delivery of postal services and the like. Nobody seeks to question them because they're in everybody's interest, and they don't cut across the interests of powerful states. But at the highest level, the highest political level, where they do cut across the interests of powerful states, can it not be said that international law is really made by powerful states for weak states to comply with, and to give the powerful states a semblance of justification for imposing their will upon the weaker states?
I'm not sure that's actually representative of international law, not just presently, but really for some time now. In the 1950s and 1960s, powerful states, and in particular the United Kingdom or France, were very much opposed to decolonization. But there was a strong political movement that brought the end of the colonial empires, and that political movement resulted in new rules of international law on the creation of statehood and self-determination, which were opposed by a lot of powerful states. But they happen. I think there is a way in which political momentum, not just political momentum from powerful states, but from different sources can generate legal change and has done so over the years. And powerful states at some point have to accept that some of these rules that do enjoy a wide degree of political support are rules that they will also find it very difficult to simply ignore, no matter how powerful they are.
Guillermo, it's very hard to wrap that up, but let me try and do so very briefly and think to articulate. I think you've described, and I was searching for a better phrase than this, but a trident of British statecraft, in which I'd include, number one, a history and a heritage of trying to bring about international order, which has been, for most of this last 250 years, in our interest to try and bring about, and that has a international legal aspect to it. It has a balance of power aspect to it as well. Two, an attempt to marry those instincts of ordering and legality with hard realities about the balance of power, about the relative share of force internationally as well, and I think those are noble traditions. And then third, and most importantly, in a forward-looking way, I think you've outlined an extremely proactive rather than a defensive agenda. Yeah. So what you're talking about is not simply the curation of something God-given in 1945 and the unthinking protection of it. You're talking about maintaining the rule of law by a system or an approach which is proactive, which is negotiation, which is the assertion of UK interpretation and interest as well. Those things are quite hard to bring into government policy, but I think they speak to the sophistication of your argument. I will end there on the grounds that the last defender of the rules-based international order is policy exchange, and I've been told to end very abruptly because this room is going to be used for a subsequent event. So I just want to thank you, the audience, for a fantastic contribution, and mainly to congratulate you, Guillermo, on the Grotius Prize and then your majestic articulation of a Grotian sensibility. Thank you very much.